Inside America's Boardrooms, the informational show for board members and corporate secretaries. Brought to you with knowledge partners NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini Goodrich and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of Inside America's Boardrooms. I'm TK Kerstetter, the CEO of Boardroom Resources, and it's my pleasure to welcome you to the show. We're going to be talking about the Department of Justice's Yates Memo and how it impacts board members and their personal liability. And joining me today is somebody who's an expert in this field. Welcome Damian Brew, who's the Managing Director for FINPRO at Marsh USA. Welcome, Damian.
TK, it's good to be here. Thank you.
So we want to get to this DOJ thing because that's a big deal. But first of all, we've never really had a chance sort of to look behind the curtain. We've always talked with directors about the front end, about what to have in their insurance policy and, you know, all that stuff, but never sort of after the fact when the suit comes in. So why don't we just take a second to educate our audience on what happens after the suit is filed. The directors are named, and now they're looking at the D&Os to say, should I be concerned or not?
Absolutely, and TK, this is a good time to have this conversation because as the first half of 2016 draws to a close, we've seen a record number of suits against corporate directors and officers, really not seen since the height of the credit crisis. You know, and a lot of the key work in terms of structuring a D&O policy is done in the front end, asking the right questions, making sure that you're right with the right insurers. They have good reputations for paying claims. Are you with the right brokers that have relationships in case the claims process goes astray? But the key part of the claim against the directors and officers really are the nuts and bolts, making sure that you're providing notice to the insurers, because if you don't provide that notice right away, their claims-made policies, the coverage could be jeopardized. And then another important part of the process is really making sure that there is smooth communication between the company, the outside counsel that's ultimately selected, defense counsel, and the insurers, to make sure that there isn't that friction in the claim process that we all hear about from time to time. And finally, it's making sure that you have the right defense counsel in place, that the insurers are comfortable with that they have consented to counsel so that nobody ends up fighting about defense costs on the back end.
Well, you make a great point. That defense counsel and getting that straight, getting somebody who's experience of knowing their way through, that really is a pretty critical issue.
It's really one of the most important issues, and one of the questions that you have to ask with insurance is, can I select the counsel that I'm very comfortable with? If you've got a decade-long relationship with a particular law firm or a particular lawyer, you should ask the relevant parties, can I use that person if I'm sued? Because some insurers limit who you can use. They have certain panels, they have certain restrictions. They may have had particular experiences with a lawyer. So it's really important that you get that straight up front. It's an important part of the process.
Yeah, well, we never talk about the back end, so that's great advice. So we wanted to talk about this Yates Memo, okay, which is sort of a directive that ended up being put out by the DOJ that is sort of all based on sort of bringing some level of accountability to the wrongdoers, some form of punishment in that sense. So talk a little bit about that memo, how the DOJ is supporting that with their actions, and then what it really means to boards of directors.
Absolutely, and you know, we come to 2015 and a lot of the credit crisis cases are being resolved, and people are looking back and they're saying, why weren't there cases brought against senior leadership of the financial institutions that were involved in the credit crisis? As you look around, none of those executives were really brought, the senior executives were brought to any kind of cases by the DOJ. So you have in September of 2015, Deputy Attorney General Sally Yates with this new policy announced by the DOJ that they're going to focus on individual accountability. They're going to say to companies, if you want to settle with us, you have to turn over all of the relevant facts about the individuals at your company who are involved in the corporate wrongdoing. That is potentially a major change, a dramatic change in the policy by the Department of Justice. Well, what does it really mean? There are some commentators who will tell you it merely codifies the existing practices across the country by the various federal prosecutors. But in any case, it does challenge prosecutors to really take a hard look at the evidence with an eye toward individual accountability. There are some commentators who will tell you, TK, even with the Yates Memo in place, there would not have been winnable cases brought against Lehman executives or any of the other prominent figures who we all know about who are involved in the credit crisis. The practical impact, what we are seeing so far, some companies, there are legal commentators who will tell you, there's a chilling effect. They may be reluctant to turn over information about their employees or senior officers, particularly where they're concerned that there may not be substantial evidence of corporate wrongdoing. And then, of course, from a practical standpoint, there is the concern that there may be a conflict of interest. You know, typically we rely heavily on inside counsel or the company's outside counsel. Given this memo, more individuals may say, I want to get my own attorney in place, and that may drive up the cases, the costs associated with a particular investigation. And frankly, if the D&O insurance is involved, it may drive up losses under D&O insurance. A lot of insurers are very concerned about that as well.
Yeah. So the directors are one level up, okay? So plus they're under the business judgment rule. You know, if they have followed normal practices and whatever, they're usually protected, you know, in that sense. But I assume, though, with this in place, it could still flow uphill in the wrong situations.
There is no question that it certainly would potentially implicate directors who are involved. You look at the meltdown type of scenarios where you have a Lehman situation, they're going to be looking across at anybody that they think may have been potentially involved and potentially in a place to prevent the underlying wrongdoing. So you have to think that directors have to be concerned about the Yates Memo as well, though it does seem to be targeted more at insiders. The company, the directors ultimately are responsible for putting in place the processes and procedures to ensure that there are adequate safeguards to ensure that people are overseeing the company to prevent this kind of wrongdoing from taking place.
Well, some of those directors, much like the CEO, those are some deep pockets. So, you know, that you know, lawsuits like to go where the money is.
Absolutely.
So, but we've seen very, you know, we can count on one hand the directors that have been held personally accountable. So, you know, the logical thing would be that this is, yes, it's a shot across the bow. Yes, it opens up the liability, okay, possibly, but the chances of that happening still are probably slim.
They really are, TK. You know, the one, we closely monitor the outcome of cases against directors and officers. Obviously, we're very, you know, people want to know what happens to these cases. They're big, you know, high-profile cases, and the reality is that about 40% of them actually get dismissed by the court without anything being paid other than defense expenses. Now, the other 40%, they are settled either using D&O policy proceeds or through corporate indemnification. And as you're saying, that is the second part of the, you know, the financial backing for directors is, you know, if they act in good faith, they have the company's indemnification behind them, and that is, you know, a very big factor. The cases where we see individuals reaching into their pocket to settle are increasingly rare. And, you know, we have so much focus today on Side A D&O insurance. The product has been improved dramatically since 10 or 15 years ago when we did see some very prominent examples in WorldCom and Enron where individuals had to reach into their own pocket. You know, we made it through the entire financial crisis, and there were some very big meltdowns there without any individuals having to go into their pocket to pay those settlements. And there were really hundreds of millions of dollars, really billions, paid to settle with shareholders, with holders of RMBS securities. All of those cases resolved, and you didn't have a dime paid by an individual.
Damian, is there any other trends that outside of the Yates Memo that board members should be aware of that might impact them in any way?
We are seeing an increase in demands against board of directors against companies to bring suits against the board of directors for corporate wrongdoing. And this can range from anything from a major cyber loss to merely going outside the policy for providing executive compensation. Anything that the creative plaintiffs bar can seize upon, they are going to, and they're going to make these demands against the board of directors. We're also seeing an increase in what we call Section 220 demands under Delaware corporate law, which are brought against the company to provide books and records, presumably to provide fodder for the plaintiff's bar to bring these derivative suits. There's an increase in these, and there was one case, a prominent case in California earlier this year, which raised the prospect that the costs involved in providing information related to these demands might increase significantly. If anything, for directors, it does play up the fact that you have to look at your policy and see what kind of coverage do I have for investigations. That's something that people haven't focused on as much in the past. I think everybody's been concerned, hey, do I have the coverage for a lawsuit? Do I have the coverage for defense counsel? But what about if I'm investigated? What kind of coverage do I have for that? Then the other major trend, and you can't talk today for 5 minutes without bringing up cyber privacy liability, and certainly that's an area that people are looking at very closely. You know, we've seen some major cyber losses over the past couple of years, and then there are a lot of commentators who think that the next major target will be directors. Well, so far the cases have not borne that out, and there have been two major decisions, one involving Wyndham and the second involving Target, and the Target one was just this month. Both were dismissed on very different grounds. The Wyndham case probably just on the amount of work that the board had actually done in the cyber area to make sure that the company was well protected. And then the Target case was more about the procedural. They established a special litigation committee comprised of a former judge and a law professor. They conducted extensive interviews. A lot of work into that process. A huge report of 100 pages. It's a fascinating, breakdown of the whole, event and how the company responded. Both cases were dismissed. Of course, this is an evolving exposure, and we're going to be looking at it very closely to see if there are truly exposures, because we look at the cyber privacy area as potentially implicating so many different insurances that this is an area people are going to look at and focus on in the future.
Well, I think the lesson here, which we've said on numerous shows, is make sure you have a process and you document that process. You can be wrong. It can be a wrong process, but you have to show that you've gone through the thought process with that. So, Damian, I want to thank you for taking the time to join us. Again, it gives us a look into something that we don't get to see all the time, and it's pretty valuable to us. So that will conclude this edition of Inside America's Boardroom. We hope you enjoyed the show. We'll be back again next week when we take a look at another critical topic that'll help you be a better board member or committee member. So we'll see you then.
Join us again next week for Inside America's Boardrooms. Brought to you with Knowledge Partners, NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini Goodrich and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.